he hear you?
I did not.
Okay, did we open the court session officially?
I did, and Honorable Judge Scranton presiding.
Okay, please have a seat, everybody. For the second time this morning, good morning. You know, I have some prepared remarks. They're a little bit different from what I did prepare. I started out with a reference to that upstanding Bills victory yesterday. And I've introduced you to Mila Gutkoff, my law clerk and a stellar attorney, and without my permission, she deleted those references to the Bills game. So what you will hear will be a redacted version of my prepared remarks. But on behalf of the federal judges here in the Western District of New York, and we are one of 94 federal districts in the country, probably ranking in the 7th to the 10th most busy district in the United States. And we're very proud of the fact that we are a very collegial court. We're a court that's very committed to the full and fair administration of justice. I think it's a terrific morning to be here. And in particular, on behalf of all of my colleagues whom you see before you, and I will introduce them in just a little bit, on their behalf, I want to welcome you here to the Robert H. Jackson United States Courthouse, and I'm sure that Greg Peterson has explained to you a little bit of the background in terms of the naming of our courthouse. So we're very much looking forward to today's program and having you here in particular. I mean, you don't know how much this means to us to have you here, and I hope you find this program as interesting today as we think you will. And then, obviously, after the formal presentations, we will have our luncheon discussions, and I think you will enjoy those as well. I and my colleagues are trial judges here in the Western District, and I was appointed to the federal bench in 1990 by President George Herbert Walker Bush. The position is a presidential appointment. It's a lifetime appointment. Judge Larry Villardo, to my left, who's seated in the witness box, and we're going to put him under oath in just a short period of time. So you know everything that he will tell you will be truthful. He was our most recent addition to our federal bench, and he's just doing an outstanding and stellar job trying cases, presiding over cases, and making certain that litigants who are a part of our federal system get as expeditious hearing on their cases here in federal court as is possible. We're very proud as federal judges and in this court to really co-host with the American Board of Trial Advocates, or ABOTA as it is better known in legal circles, this 4th annual James Otis Lecture to commemorate and recognize Constitution Day. It was on September 17th, and I'm sure you all now know this, 1787, that the founders of our great nation, 39 state delegates, voted to approve the draft of our United States Constitution. And what an important day today is. Our Constitution, 4,543 words of it, are inscribed in the curtain wall entrance on the pavilion downstairs as you enter the courthouse. You've probably seen that. And it's there 7 times over. So if you think you can memorize something by reading it 7 times, the Constitution is there for you to do that. The document itself, it's really an interesting document. It's a living document, but it's also an imperfect document. It's the product of hard-fought compromises that were reached over the course of several summer months of debates in Philadelphia. It is also a changing and changeable document. There are, as you probably already know, 27 amendments to our federal Constitution, and it is the series of compromises that give our Constitution, that document, its persevering power. So on this day, some 230 years after the signing, we celebrate it with today's program. And what's the topic today? Protesting constitutional change. Think about that. Protesting constitutional change. Something that probably you're a part of almost every day, or at least something about that topic you hear about almost every day. Our focus will be the First Amendment. And that First Amendment states as follows, and I'm going to quote it: Congress shall have no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievance. It can be dumbed down and it can be simplified a little bit, but it's critical to what our nation is all about. Free speech, freedom of assembly, freedom of a religion, freedom of press, all encompassed in this First Amendment to the United States Constitution. Specifically, we celebrate and consider the guarantees and the limits of the right to protest, and we do it in a building named after Justice Robert H. Jackson, who once wrote of the majestic generalities of the Bill of Rights. But today, we will consider the Constitution and the First Amendment on a more familiar personal level for us all. For example, recently, Colin Kaepernick's refusal to stand for the national anthem, Black Lives Matter, and the manner in which they move their point to the forefront of consideration in our country. Matters like flag burning and the like, all are encompassed. What amendment? First Amendment. This First Amendment topic happens to be quite a personal one for me. 1969 was the year I graduated from Howard University Law School. That year, among many other things that happened on campus, students took over the law school, demanding changes to the curriculum and administration. Although I, as a student, sympathized with the protesters and many of their demands, I happened to be one of only a handful of white students on a predominantly black campus at that time. Not only on that one occasion that I referred to was I the subject to a chant, "Hell no, Whitey must go," but on that occasion, I needed an escort from campus on that occasion to ensure my safety. So as you can see, the poignancy of that experience in connection with our topic here today. This is what the laws around protest seek to establish: the right of legitimate expression, which can be an effective engine for change, but not the right to put others in danger. That personal experience of mine and others that were like it while I was in law school, including being there when the protests were taking place after the assassination of Dr. Martin Luther King, all of those had a real impact on me. It made, for me, the application of constitutional principles real and not abstract. I'm anxious to hear from our honored guests and our speakers and to get your input and your thoughts about what's going on in your world, in our world today. I know that there was a lot of hard work that helped make today possible, including the efforts of many of your teachers, and to them we're very grateful that you are participating with us and allow your students to be here with us today. The administrators at your schools that made this possible, and our own court and technical staff. Hard work also from today's speakers, whose discussion I am certain you will prove to be for you insightful and also enlightening. Today you will hear from the legendary Buffalo newsman Lee Coppola. He told me how to introduce him. All right, so my terms weren't as glowing as that, but he really is a legend in a very special profession that is linked intimately to the First Amendment. And we have some stellar representatives of ABOTA. Remember, the American Board of Trial Advocates, Barbara Schiffling, who is president of the Buffalo chapter of ABOTA, Greg Peterson, who is co-founder of the Justice Jackson Center in Jamestown. I mean, it's amazing the relationship that we've developed over the years, and Greg certainly has been in the forefront of that, and it makes for a better court, and it makes for a better center, I think. We also have Professor Anthony O'Rourke from SUNY Buffalo Law School, who will be introduced by ABOTA's Mike Purley. And without all of their efforts, frankly, none of us would be here today. We also have some esteemed judges in the courtroom today that will be sharing lunch with us all. We have my colleague and the newest member of our federal bench, Judge Lawrence J. Villardo, Magistrate Judge Jeremiah McCarthy, Magistrate Judge Leslie Fascio, Magistrate Judge Hugh B. Scott, and sitting in those very important juror seats, Buffalo City Court Judge Susan Egan and Buffalo City Court Judge Barbara Johnson Lee. Judge Martocci is completing her calendar at Buffalo City Court and will join us shortly. All of us will join you for lunch after this presentation. We'll be there to discuss with you topics, issues, things that are on your mind, and hopefully have some answers for you. Much awaits all of us this morning, so I'm not going to take up more time. I eagerly invite Ms. Barbara Schiefling to the lectern to get our program started. President Schiefling, please come and join us.
Welcome to the James Otis Lecture for 2016. We're so happy you are here. And distinguished members of the judiciary, Mr. Coppola, Mr. O'Rourke, and Mr. Peterson, thank you. I'm Barbara Schiefling, current president of ABOTA. And ABOTA, it means American Board of Trial Advocates. This is one of the groups that's supporting this event. Mike Purley, who spoke to you yesterday and the day before, is a strong, strong member of ABOTA. The people who are in ABOTA have to be approved to be in, and they are people who have tried a large number of trial juries and have good ethical standing. Well, what does ABOTA do? One thing it does is it promotes and protects the jury system for civil trials. Trial by jury is protected by the 7th Amendment to the U.S. Constitution. But it also promotes programs to help lawyers who try cases in the courtroom become better. And it also promotes good ethical behavior. Every other year here in Buffalo, ABOTA promotes a mock trial and invites really good trial lawyers to demonstrate their craft. And it also includes very excellent trial lawyers from all over the United States who come to Buffalo to take part in this mock trial. And then other local attorneys sit, just as you are, and watch the trial and watch these attorneys work. It also promotes a program called Civility Matters, which promotes civility among attorneys. Civility means treating the court, your opponent, and witnesses with respect and according to the rules of ethics in our profession. And finally, as demonstrated by today, ABOTA promotes civics education. It believes that teachers are the key to preserving the health of our democracy because they educate the next generation about the rights and responsibilities of citizenship. It puts on a teacher's law school and the James Otis Lecture Series, which is why we are here today. And this lecture series always includes an issue involving a constitutional question, and as you heard, this year it is about constitutional protections of those who assemble and protest. So on behalf of ABOTA, I thank the Honorable Judge Scretany for allowing us to be in this magnificent courtroom and for his help in planning the program. And for Greg Peterson from the Jackson Center, and Mr. O'Rourke and Mr. Coppola for speaking to you. And finally, thank you to you and your teachers for being present and for giving such good attention to what we hope will be a wonderful event. So welcome.
Judge Scretany, thank you for already introducing him as simply the legend. Your Honors, thank you. It's always a privilege to be here at the Robert H. Jackson Federal Courthouse. And you might ask, why is our next speaker a legend? Well, he is now the retired dean of the St. Bonaventure Journalism School, which from 1996 to 2011 he held. He was most recently inducted into the Buffalo Broadcasters Association Hall of Fame. Why did that happen? He's got quite an incredible career. He graduated from St. Bonaventure University, Go Bonnies, 1964. He was in the military for 2.5 years. Came back and was hired in 1967 by the Buffalo News. His articles on organized crime and the Witness Protection Program actually were the inspiration for a 1980 movie called Hide in Plain Sight. I suspect none of you probably here in this audience saw that, but you have, right? Okay. And I suspect when Judge Martocci gets here, she can talk about her dad as well. Lee Coppola left the newspaper after 16 years to pursue a career in TV journalism. In 1983, he was hired as a troubleshooter for WKBW TV's Eyewitness News, and later served as investigative reporter at another WIVB. He then went on to do something which is incredible. He just decided to go into law school, which is great. He'd seen the other side, and then he decided to go and become a lawyer. So he graduated from the University of Buffalo Law School. He was a U.S. attorney from 1992 through 1996, and then had an incredibly distinguished career at his alma mater at St. Bonaventure, leading that school of journalism. I could go on, but he's well worth listening to because his experiences are vast and many. And so, ladies and gentlemen, Lee Coppola.
Good morning. One correction, I was an assistant United States attorney. I think Dennis Vacco would get very upset if he found out I was the U.S. attorney. I'm here today to talk to you about protests and protests that I have in my career as a journalist covered. So I'm going to bring you back 45 years ago this week. I was standing outside the walls of a place called Attica Correctional Facility in Attica, New York. It was a dark and dreary day. It was raining, and I was there with a whole bunch of reporters from around the world. We were covering what was called the Attica Revolt. Prisoners had taken over the prison, inmates had taken over the prison 4 days prior to that. They were protesting. They were protesting the fact that they were not getting the sufficient food. They were protesting the fact that the conditions there were deplorable. They were protesting the fact that they were not accustomed to the kind of, well, of course, they were not accustomed to the kind of treatment they were given by corrections officers. They weren't getting proper medical attention. And as an aside, a majority of the prisoners were either Latino or black. A vast majority of the corrections officers were white. So it was a racial antagonism that was there behind the walls. All right, so I'm standing outside because we had been told that this was the day the state was going to retake the prison. And I'm standing outside and I'm watching heavily armed corrections officers, state troopers, sheriff's deputies walk into the prison with rifles and shotguns, and I'm wondering what is going to happen next. Well, what happened next was a helicopter, a appeared above the prison yard and started circling. And from the helicopter, a bullhorn, a voice going, "Put down your weapons. Put down your weapons. Release the hostages." Because the prisoners, when they took over the prison, took control of the prison and also captured hostages. Release the hostages. And then, all of a sudden, tear gas canisters were being dropped from the helicopter. And as the tear gas wafted over the walls of Attica, those on the other side, myself included, the tears coming down from the tear gas, and I don't know if it was a tear gas, I started hearing the gunfire. Those heavily armed officers inside the prison were shooting at the prisoners. And they were shooting they were shooting rifles and they were shooting shotguns. And it was like firecrackers going off. Pop, 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 pop. And it lasted for like 6, 7, 8, 9, 10 minutes. And I'm standing there wondering what in the world is happening. The prisoners had no weapons other than homemade knives. They had no guns. The only weapons were in the hands of the law enforcement people. It turned out that day, 39 people were killed. 10 of them were hostages and 29 were prisoners. It turned out that day, many of them were killed after they surrendered because of the anger and the antagonism and the animosity on the part of those who were in the charge of the prison. All right, let's talk about it now. That was a protest. It was really an illegal protest. Prisoners aren't supposed to take over a prison, but they had no other alternative in their minds. They had to show that the conditions inside that prison were deplorable. They had to show that we can't live like this anymore. So they took control of the place where they lived. It's illegal. You're not supposed to do that. But also the retaking of the prison, the publicity that entire uprising and the bloody rebellion that it was, changed things in American penal systems. Penal authorities recognize that you can't have predominantly white corrections officers administering and guarding predominantly people of color. So that's changed considerably throughout the United States. Specifically at Attica, all of a sudden, medical conditions improved tremendously. More guards were hired, and they weren't just hired from the surrounding rural community. They were hired from New York City and metropolitan areas so they could understand the culture of the inmates better, because that was a discord between corrections officers and the inmates. You know, Judge Scrutiny talked about when he was in college in 1969. In 1965, I went into the Army, as Greg told you, and I was an officer at a place called White Sands Missile Range, New Mexico. At that time in American history, there was a thing going on in a country called Vietnam, called a skirmish at the time, a kind of a war. And my job, one of my jobs at White Sands Missile Range, was to talk to new recruits and to give them a pep talk, because they were on their way to this war zone in Vietnam. And I would tell them how important it was and how vital it was for them to go and defend America. And they would go off to Vietnam, and I don't know how many of them never came back. I have no idea. But I know when I left the Army and I went back to Buffalo and I was hired on a newspaper, protests were erupting throughout the country. Protests mostly on college campuses. Young men and young women, a couple years older than you are here, were protesting because they felt this was an unjust war. And you know, as I watched those protests, and most of them were peaceful, some of them resulted in death. There was a place called Kent State. 4 college students were killed by National Guardsmen because they were conducting what was their right to protest peacefully against a war they felt was unjust. And those protests changed my mind about that war. And I said, you know, this war was wrong. And I regretted standing in front of those bright-eyed soldiers and telling them how important it was to go off to Vietnam and to fight. I regretted that because I realized that it was wrong And I realized that because of the protesters, and because of those protesters, because of those peaceful protests throughout the United States, the government also recognized that it was wrong and eventually found a way to get out of Vietnam. So protests can produce results. Protests are powerful. I don't know if Colin Kaepernick's protest will result in anything, but he's shedding a light, he's shedding a spotlight on an issue he feels is important in the United States. So remember that they can mean something. They can promote change. They can instill people's minds with ideas that maybe people didn't have before, or opinions or views that people didn't have before. And in about a half an hour, by the way, there's going to be a peaceful protest at UB, because they're protesting the fact that the government is considering allowing a oil pipeline to run through North Dakota's Native American lands. So even here, in our community, in a half an hour, there's going to be a peaceful protest because some people oppose an oil pipeline going through a state on Indian lands. Thank you all very much.
Lee Capola, those words were compelling. Thank you very much. That was my era you were describing as a student. Thank you for that presentation. And you may remember earlier this week when Mike Purley spoke at your schools in preparation for this program. During his presentation, he discussed several cases from the United States Supreme Court and the impact those cases had on the rights of protesters. I just want to go briefly down the path of how you get to the Supreme Court. So let's start. Supreme Court, of course, is the most important court of the land. District courts like this one are where much of the action really occurs. District courts are the trial courts of a three-level federal court system. And in fact, the drafters of the Constitution themselves gave Congress the power to create these courts. Article 3 of the Constitution states that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Now, believe it or not, I was not around when the Constitution was created. Judge Scretany was. But if I had been, I would have suggested a different word than inferior. The Western District of New York, which is where you are right now, where you're sitting, is the court where one of the cases that you heard about earlier this week from Mr. Purley began, and that's the Schenck versus Pro-Choice Network of Western New York. Like all district courts, the Western District of New York is made up of district judges like Judge Scretany and magistrate judges like myself. Federal district judges are nominated and appointed for life by the President of the United States, subject to confirmation by the Senate. And this way, they cannot be removed merely because they decide a case in a way with which some people may disagree. Magistrate judges, such as myself, are appointed, and we are often said to be on the front lines of litigation, and we oversee potential proceedings in both criminal and civil matters. We issue decisions and recommendations that shape the scope of a case, and sometimes we resolve those disputes from start to finish. District courts are abuzz with activity. Every day, people are arrested. They're brought to this court for arraignment. They're brought to this court for hearings, trials. We have important civil matters that are addressed here, and a civil case simply means that it's not a criminal case. That's oversimplifying it, but those are the two categories that we generally talk about, civil and criminal cases. No one in a civil case is accused of a crime. Instead, the defendants in a civil case are alleged to have harmed a plaintiff in some way, such as here, violating the plaintiff's constitutional right to freedom of speech or freedom of assembly. Now, as I said, I don't think district courts are inferior, but despite best efforts, I also know that they are not infallible. And Congress knew that also. So it developed an appellate system to which litigants who believe the district court erred could appeal. Like the district courts, which represent geographic portions of the country, appellate courts are split into circuits. Each hearing appeals from certain designated locations in the country. Now, in our part of the country, appeals are heard by the Second Circuit Court of Appeals. And that is the court that heard the appeal in the Schenck case you heard about, that Mr. Purley told you about. In fact, the Second Circuit hears cases from all over New York State, Connecticut, and Vermont. In total, there are 13 courts of appeals. Now, decisions from those 13 courts of appeals can be challenged in our highest court, and that is the Supreme Court of the United States. It's located in Washington, D.C. Cases can also reach the Supreme Court from state courts around the country. If a decision of the state's highest court is challenged, that challenge may be heard by the Supreme Court, as in the other cases that Mr. Purley discussed with you this week, such as Terminiello versus the City of Chicago, which began in Chicago City Court. That progressed through the Illinois State Courts of Appeals and was eventually heard by the Supreme Court of the United States. So the Supreme Court consists of 9 justices who hear cases from all over the country. Majority rules on that court. 5 votes is all that is required to dispose of a case. Now, I'm going to let your teachers quiz you on whether the Constitution requires that there be 9 members of the court. Well, the hint is, if 9 are required, we'd be in trouble right now because we have 8. So generally, the court hears only those cases. The court hears only those cases it decides are sufficiently important, and they issue what are called writs of certiorari, which allow these cases to be brought before that court. So that is how cases reach the Supreme Court. They enter through the 3-part federal system: district court here, circuit court or appellate court, and the Supreme Court. Or they arrive through an appeal from the highest state court to the Supreme Court. So thank you for your time. I hope you enjoy your day here at this courthouse. We're very proud of it. I look forward to talking to you at lunch. Until then, I will turn to someone whose word is always final and infallible, Mr. Purley. He's of the law firm of Hurwitz and Fine, and he's very active with our local abota. Mike?
All right. All right, thank you, Judge Scott. And while Mike Purley is making his way up to the podium, I just want to state this on behalf of the court and all of the participants this morning, that Mike Purley, probably more than anyone else, in fact, more than anyone else, hands down, is responsible for our Constitution Day program, the Constitution Day program over the course of 4 years, and the consistently extremely high quality of that program, which I think benefits not only the court, but I'm sure all of you and all of us that have the opportunity to participate in Constitution Day. So, Michael, thank you on behalf of all of us this afternoon for all the work that you have done.
I'll take the opportunity to explain to you what really goes into putting this program together when we wrap things up at lunch. But, Your Honor, Judge Scredny, thank you very much for the kind words, and may it please the court and honorable judges and guests. It's my distinct pleasure today to introduce Anthony O'Rourke. He's a professor at the UB Law School. When you put a program like this together, one of the things you hope to find is somebody that can take this topic and really understand it and be able to communicate it. And one of the ways that people can do that, and one of the ways that Professor O'Rourke has done it, is to have a career that has involved him both as a lawyer after graduating from the prestigious Columbia Law School. He was a practicing attorney. He also became a law clerk, not only to a district court judge, but to a circuit court judge, a circuit court of appeals judge, where it was his responsibility to assist the court in determining issues and resolving issues and seeing both sides of the story. But when you come to a program like today, where we talk about assembly and protest, I was fortunate to find out that Professor O'Rourke, and this is not in his biography, but has participated in these protests. So if there were one person that I could have selected in the city of Buffalo to give you the best perspective on constitutional issues that are presented before us today, it would have been Professor O'Rourke, and it is my pleasure to introduce him now.
Thank you, Mr. Perley, for that wonderful introduction, and especially for all of your work hosting and organizing this program today. And I also want to thank Mr. Coppola for sharing those powerful images of individual conflicts that he has witnessed between protesters and law enforcement officers in Attica, in a prison, on college campuses, that have given rise to real social, political, and I'm going to argue today, constitutional change. Now I'm going to say another few names that might also evoke powerful images for some of you. These names are Eric Garner, Michael Brown, Freddie Gray, Sandra Bland, Philando Castile, Alton Sterling, Trayvon Martin. If you've heard of any of these names, if they evoke any feelings in you, maybe fear, maybe a sense of injustice, maybe anger, it is probably thanks to ordinary citizens exercising their constitutional right to protest. These protests have taken many forms. You may have read activists reporting on Twitter from the front lines in places like Ferguson, Missouri, and Baton Rouge. You may have seen people marching in the streets in your neighborhood to protest police brutality. Maybe some of you have even marched yourselves. You may have seen Colin Kaepernick take a knee during the national anthem. Maybe you disagreed with his choice. Maybe you didn't. Either way, you probably listened to what he had to say about his perceptions of police violence in this country. These protesters, including perhaps you, might not agree on what should be done to address the problems of police violence, but they have organized very effectively around a common theme: Black Lives Matter. Today, I want to talk about how the Black Lives Matter movement connects to the Constitution. What does it have to do with the Constitution? I want to talk about how the Constitution shapes movements like Black Lives Matter, but I also want to talk about how movements like Black Lives Matter shape the Constitution. And this second question is the one I want to focus on how protesters, including protesters your age, are shaping the Constitution. I'm going to argue that the right to protest is what enables students like you to make the Constitution a stronger, more vital, better reflection of the values that make our country worth celebrating. Of course, as Judge Scott helped lucidly describe, the United States Supreme Court has the power to shape the Constitution's meanings with decisions like Brown versus Board of Education, but the right to protest is the instrument by which you can make sure the Constitution's promises are realized. And I'm going to make this argument by talking about constitutional law, but also by sharing one of my experiences as a protester, marching in New York City in response to the death of Eric Garner, who, for those of you who don't know, was killed by the police while he was being arrested on the street for selling loose cigarettes. I want to use this experience to help build an argument about how protesters are helping to reshape our understanding of the Constitution, and particularly of what the Constitution says about policing and racial profiling. But before I do this, I want to take a moment to thank both ABOTA and the Robert H. Jackson Center for co-hosting this event, and especially to thank Judge Scrutiny for sharing some of his experiences of protests in law school, and also for hosting us in open court to talk about these issues. It is a testament to Judge Scrutiny's commitment to the Constitution and to this program that he had just one substantive suggestion with respect to this speech, and that is that you leave the courtroom today knowing what your rights are if you decide to engage in protest. And I couldn't agree more that this is the most valuable information I could impart. So let me briefly go over some points that you should keep in mind and take away with you. First, the First Amendment of the Constitution provides that the government cannot abridge your freedom of speech, as you know, and in practice, this means that the government cannot restrict your right to protest based on the opinions that you are trying to communicate. This does not mean that you have the right to incite your fellow citizens to commit crimes. The Supreme Court has said in Brandenburg v. Ohio that the government may restrict public speech that is, and here I quote, directed to inciting or producing imminent lawless action and is likely to incite or produce such action. That means that your protest may cross a line if you are actively encouraging others to violate the law. If you are encouraging other audience members to single someone out and harm them, the police may step in. But they may not step in because they dislike your opinion. And I'm going to come back to this aspect of the free exercise clause, the First Amendment's viewpoint neutrality, as lawyers call it, in just a moment. Second, the First Amendment gives you the right to peacefully assemble. That means that you have the power to organize together and protest in streets, public parks, and other places known in the case law as traditional public forums. For some large protests, the government may require organizers to apply for permits, but the government may not deny a permit simply because it dislikes the protesters' message. And even if you don't have a permit, you may still march on sidewalks and conduct a protest that does not interfere with the day-to-day activities of your fellow citizens without being arrested. Of course, police may patrol a march to ensure public safety. You may be stopped by a police officer. So if you are, during a protest, you should stay calm, you should be respectful, you should not resist or run away, but you are entitled to respectfully point out that the First Amendment protects your right to peacefully protest. You may also ask the officer if you are free to leave. And if the officer says yes, that means you are not under arrest, and you can calmly and quietly walk away. If you are arrested, you may ask the officer why you are being arrested, but otherwise it is a good idea to remain silent. Memorize a phone number of someone you want to call, ideally a lawyer, but otherwise someone who you can rely on to answer the phone and get in touch with the lawyer on your behalf. Maybe even write the number down on your hand using indelible marker. For more information, check out the ACLU's webpage on the rights of protesters. It's a great summary of your constitutional protections, and it was helpful to me in summarizing those protections to you today. And these tips form the core of how the Constitution protects your rights as a protester, how the Constitution shapes protest. But now I want to move on to discuss how movements like Black Lives Matter shape the Constitution. I want to start with the fact I mentioned earlier that the government may not restrict your right to protest based on the opinion you hold. That is to say, the First Amendment is viewpoint neutral. There are reasonable people who think that this neutrality is unwise. It means that the same First Amendment that protects your right to protest also protects the rights of people with hateful and intolerant views to protest. That case I mentioned earlier, Brandenburg v. Ohio. In that case, the Supreme Court held that the First Amendment protected the KKK's right to hold a rally at which protesters burned a cross and shouted horrifying racial slurs about African Americans, Jews, and other minorities. Should we celebrate a vision of the First Amendment that gives them just as much of a right to burn a cross as it gives you the right to march in opposition to cross burning? It isn't stupid or unpatriotic to ask this question. Indeed, the First Amendment was not originally understood at the founding to be viewpoint neutral. The same founding fathers who ratified the First Amendment also supported sedition laws that punished people and subjected them to imprisonment for criticizing the government. In the 20th century, however, the Supreme Court decided that the First Amendment should protect the views of radicals who wish to criticize or even overthrow the government. And in my view, it is this aspect of the First Amendment, even though you can disagree with it, but the viewpoint neutrality of the First Amendment, and with it the power to protest your government, that gives the document its vitality. It is what makes the right to protest a valuable instrument for students like you to become agents of constitutional change. And as you know, and as Judge Scrutiny reminded us, the Constitution is a changing document. When it was ratified, it was understood to permit slavery. And it was later understood to permit racial segregation of every aspect of public life, including where you lived, where you went to school, even whom you could marry. When individuals organized to challenge these practices, they were challenging what people in power thought the Constitution meant. For example, the Fugitive Slave Act required law enforcement officers in states that had abolished slavery to capture, return escaped slaves back to their owners. When Frederick Douglass risked his life to speak in public in opposition to this law, he was challenging an idea of the Constitution that treated African Americans as property. In his words, he was challenging the idea that by ratifying the Constitution, our fathers entered into a covenant for slave catching. Over a century later, Dr. King wrote from his Birmingham jail cell to challenge a segregationist government that attempted to suppress nonviolent protests using attack dogs and police beatings. He wrote that, and I quote again, "It is wrong to urge an individual to cease his efforts to gain his basic constitutional rights because his quest may precipitate violence." In other words, Dr. King was challenging a vision of the First Amendment that permitted the government to attack you because it didn't like your message. These citizens used protests to change our public perceptions of the Constitution, and these perceptions, these changes in perception, were later reflected in constitutional amendments and in Supreme Court decisions like Brandenburg that made the Constitution a better document. Their examples show that if protesters are smart, if they are organized, and if the message that they are conveying resonates with our best selves, they can change our perception of what the Constitution should be. And this brings me back to the question I started with. How do movements like Black Lives Matter protect and shape the Constitution? And here, I'd like to start answering the question by sharing my thoughts on a Black Lives Matter protest that I attended in New York City. It was a December day, a sunny one, and thousands of us gathered in downtown Manhattan to march through the city. Apart from the beautiful weather, one of the things that struck me the most about that day and about the march was the clarity of vision of the organizers. Organizers who were not much older than you. I didn't attend that protester as a law professor. I attended it as a citizen standing alongside other citizens. Some of the citizens that I was standing alongside were powerful, prominent politicians, very respected members of the clergy. I saw a few famous constitutional lawyers, and there were other people there in positions of public influence. Some of the citizens that we were standing alongside included high school students who didn't yet have the right to vote, and some of the citizens we were standing alongside weren't even in the legal sense citizens. They were recent immigrants to the United States who were trying to make their adopted country a better place. And we were all being led, powerful politicians, high school students, non-citizens, by men and women only a few years older than you, men and women who were committed to making change. Now, what does the change that they were trying to effect have to do with the Constitution? I think a great deal. That day we were protesting the death of Eric Garner, but what sort of change were we trying to make in Eric Garner's name? Not everyone attending the protest would have agreed. Indeed, by its very nature, a successful protest brings people together who do not agree on the details of everything. One organizer, Netta Elzy, eloquently characterized the message of Black Lives Matter by saying, "Our demand is simple, stop killing us." Other protesters that day were not as eloquent. A small fraction of the protesters gained outsized media attention by shouting for the death of cops. This was an embarrassing and, in my view, horrifying exercise of the right to protest, and it was a harmful one. It sought to devalue the lives of the many police officers that struggle every day to do the right thing by the communities they serve. And devaluing lives is the opposite of what the organizers that day and the opposite of what the Black Lives Matter movement is trying to accomplish. And the core message of the protest, opposition to police brutality, is deeply connected to the Constitution. I talked about the Constitution as a document that has been improved by the actions of protesters like Frederick Douglass and Dr. Martin Luther King. We shouldn't assume that their work is done. When protesters are speaking out against police violence, they are asking for a different kind of policing. They are asking for a more just and indeed more reasonable kind of policing. And here I come to my experience as a criminal procedure professor. As a criminal procedure professor, this demand for reasonable policing calls to mind a particular constitutional provision that is deeply relevant to how police do their jobs and how we live our lives, and that is the Fourth Amendment. This amendment provides, in part, that, I quote, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." So, one question we might ask, and this question has significant ramifications for millions of citizens, is whether the Fourth Amendment prohibits a police officer from stopping and searching a person because of their race. Suppose that a police officer spots a driver making a right turn without using a signal. That's a traffic violation. And the officer would have objective grounds to pull that driver over and to give him a warning, maybe even give him a ticket. Now, suppose that that driver who violated the traffic laws happens to be African American, and that if he had been white, he would not have been pulled over. Indeed, suppose that the traffic violation was just a pretext. The officer didn't care about the right-hand turn. The officer is pulling the driver over because he was African American, or because the fact that he was African American led the officer to think he had drugs on him. Does it violate the Fourth Amendment for police officers to make that traffic stop? The Supreme Court addressed this very question in Wren versus United States. There, a police officer used a traffic violation, a right-hand turn without a signal, as a pretext for pulling over an African-American driver. And as it turned out, that particular driver was carrying crack cocaine. And the Supreme Court had to decide whether the driver could be convicted based on evidence that the police officer seized during that traffic stop. But the broader question that the Supreme Court was addressing, whether the Fourth Amendment prohibits pretextual stops, whether it prohibits racial profiling, isn't just relevant to people who commit crimes. It is relevant and has significant implications for millions of law-abiding men and women of color. And there is certainly a good argument to be made that the Fourth Amendment prohibits racial profiling of the kind that occurred in Wren. Maybe you're making the arguments in your head right now. The Fourth Amendment prohibits unreasonable searches. And most people would agree that it is unreasonable to stop a person because of their race. But in Wren, the Supreme Court decided that the Fourth Amendment does not prohibit pretextual traffic stops, and with it, that the Fourth Amendment does not prohibit racial profiling. According to the court, the Fourth Amendment does not give judges license to inquire into the subjective motivations of police officers conducting a stop. The relevant question under the Fourth Amendment, according to the Supreme Court, is whether, as an objective matter, the police officer has probable cause to make a stop. So, if a driver makes a right-hand turn without using a signal, the police officer objectively has probable cause to stop that driver for a traffic violation. Easy enough. It does not matter for the Supreme Court if the actual reason for the stop was to look for drugs. It does not matter if the reason why the driver, or rather why the officer suspected that the driver had drugs, was because the driver was black. By now, some of you are thinking, look, regardless of whether the Fourth Amendment permits this type of racial profiling, it is certainly unconstitutional, and you're correct. In Wren, the Supreme Court emphasized that even if racial profiling doesn't violate the Fourth Amendment, which was ratified in 1791, it violates the 14th Amendment's guarantee of equal protection of the laws, which was ratified after the Civil War. The problem is that as a procedural matter, it is very difficult to win an equal protection claim based on a police officer's selective enforcement of the laws. As a practical matter, it doesn't happen. And that means that the Supreme Court's interpretation of the Fourth Amendment is the one that shapes how police officers and people of color interact in everyday life. And the Black Lives Matter movement is trying to make those day-to-day encounters between police and people of color real for those of us who, like myself, feel comfortable in the presence of police officers, in part because of our race and in part because of our social position. By making these encounters real, young protesters are challenging the assumptions that supported the Supreme Court's reasoning in cases like Wren. By organizing around a powerful and well-crafted message, protesters your age are becoming new voices for constitutional change. Some of you may go to law school. I suspect a good number of you are thinking about it. Perhaps one of you will be sitting where these judges are today, or even sitting on the United States Supreme Court. Certainly, those positions will give you the power to influence the Constitution. But you do not have to wait until you graduate from law school. You don't even have to wait until you graduate from high school to help bring our constitutional doctrine into conformity with your best understanding of the Constitution's values. Your rights as a protester give you the power to help make constitutional change and to continue the work of visionaries like Frederick Douglass and Dr. Martin Luther King. Thank you.
Thank you very much, Professor O'Rourke. It goes without saying, and I'm sure nobody would dissent or disagree that you fulfilled your keynoter charge to the ultimate, to the very ultimate. I think what you made happen for all of us was bring to life the First Amendment and the Fourth Amendment and bring it home to our everyday lives. So thank you very, very much for your presentation, doing that, and being here with us today. I think for the first time in 4 years, ladies and gentlemen, we're on time. And it's amazing to me that that's the case, but we will be adjourning in just a moment or so, and I'd like to leave you with a couple of thoughts, if I may. I think you can appreciate how critical and how important this topic involving assembly and speech and expression in the First Amendment and the Fourth Amendment is or slash are. Our objective was to give you a little bit of a practicum, a little bit of a manual approach to what you can do and perhaps not do when it comes to protesting and making that decision to protest, the how and why of doing that. I suggest to you this, that you now know how. What you should be doing next is, if you decide that there is something that moves you to protest, that you become knowledgeable as to why. Make an effort to study, make an effort to think, make a conscious, intelligent decision on what you hope to accomplish. If you follow the media accounts sometimes, I think it's very embarrassing to see individuals that are out there protesting, and when they're asked why, they don't know why. They're caught up in the movement, so to speak, but you don't accomplish things by not knowing why. You don't accomplish things by not working hard to become knowledgeable in the ultimate objective that you have for being where protesting might be taking place or why you are organizing matters. You have to have an open mind in terms of What is the real issue? If I can leave you with a couple of thoughts, I would like to do that. And from my standpoint, the issue of race, that's not what is the root or what's wrong with America. From my standpoint, the issue of race is what makes America great. America is what you see here in this particular courtroom. America can only be better if we together want and try to make it better. What does that take? That means you have to make a commitment to not accepting the status quo. You have to question the status quo. You have to understand what will make the status quo better. I mean, Lee Coppola, you couldn't have done any better in terms of bringing reality to all of us and maybe inspiring us to think through a little bit better and a little bit more profound these key issues that are simple in many respects. But the more knowledgeable we become, the more likely we'll be, or more unlikely that it will be, that we'll be taken down the wrong path. We want to do what's right. We don't want to do what's wrong. And challenging the status quo is one of the ways that we can make America a better place for ourselves, for our family, and that's critically important. I hope that you feel as I do today, that you're going to want to learn more and do more and make a commitment to contribute to what America is all about. And consider race as the inspiration for questioning the status quo, but not for depressing your efforts, but for inspiring your efforts. I hope today's program has made as significant an impact on you that I think it has on me. We're never too old, despite what Judge Scott said about my being there when the Constitution was written. I still learn things every day. And today was, thank you, Judge Fascio, yes. Yeah, same hairdo. No, the barber is no longer around. But, there's just so much that we can take out of a program like today. Think a little bit. We're going to start lunch soon, but think about what issues this brought to your mind, what questions you might have that have been unanswered. And all of us, my colleagues here and from federal court and our wonderful, wonderful city judges and all of our experts that we've brought in for today, we want to work with you because it's you and your fresh ideas and your understanding of the Constitution that will make us better. Hopefully we can help you leap over a couple of steps so that it doesn't take you as long to understand what the Constitution is all about. Hopefully we can help you just as you help us, and then we can continue that from generation to generation to generation. So thank you, Abota. Thank you, all the participants. Thank you, faculty and administration. Thank you, Mila. Thank you, ladies and gentlemen, for participating. We'll see you at lunch. Thank you.